Can you show me examples of holographic wills? Have you ever wondered what a holographic will looks like? This type of will is quite unique and can be a handy option in certain situations. Let's break it down together. A holographic will is a handwritten document created by the person making it, known as the testator. Unlike standard wills, it does not need witnesses or notarization, making it simpler in some cases. However, not all states recognize these wills, and the rules can vary based on where the testator lives. To give you a clearer picture, let's look at a basic example of a holographic will. Imagine it starts like this. I, John Smith, being of sound mind, write this as my last will. Then John might specify, I leave my house at 123 Main Street to my daughter, Jane Smith. I leave my car to my son, Michael Smith. All my remaining property should be divided equally between my two children. Finally, he would sign it, signed John Smith. Now, what are the key elements that make this document a valid holographic will? First, it must be entirely handwritten by the testator. If any part is typed or printed, it usually cannot be considered a holographic will. Next, the testator must sign the will, and in some states, including the date is also necessary. The document should clearly express the testator's intention for it to serve as their will. It also needs to include instructions on how property and assets should be distributed after death. Lastly, the testator must be of sound mind, meaning they understand what they are doing when writing the will. Holographic wills can be particularly useful for older adults who may need to make quick changes to their estate plans or who do not have easy access to legal assistance. However, these wills can lead to complications during the probate process. Courts may question the authenticity of the will or whether the testator was mentally capable when writing it. When a holographic will goes to probate, the court checks if it meets the state requirements. They may need to verify that the handwriting is indeed that of the testator. This could involve calling in witnesses or handwriting experts to testify. The court will also look for proof that the testator had the mental capacity to create the will. It is important to note that not all states accept holographic wills. Even in states that do, there are risks involved. The absence of witnesses can make it harder to prove the will's validity, and disputes among family members are more common, especially if the handwriting is unclear or if there are questions about the testator's mental state. Holographic wills might be used in emergency situations when someone cannot access a lawyer or notary. They can also be suitable for simple estate plans or for individuals in the military or traveling. While these wills can serve a purpose, they are not the best choice for everyone. Standard wills, prepared with legal guidance, are generally less likely to be challenged and offer more protection for the testator's wishes. It is wise for older adults to consider consulting an estate planning attorney to ensure their wishes are clearly documented and legally protected.